Good morning, everybody. My name is James. I'm one of the educators here with Insight. I'd like to begin this morning by acknowledging the traditional owners on the land on which we're coming to you from here in Meanjin in Brisbane, and also the traditional owners of all the lands which everybody is meeting today. And to pay my respects to elders past, present, and emerging. And I guess as we gathered today as well to also recognise that it is International Women's Day as well. And the theme this year for this special celebration for women around the world is women supporting women. So I'd like to just recognise all the women that have supported me in my life, professionally and personally. And yes, today, look, thank you for joining. I'm very excited about the topic today. I think it's one that, well, I'm certainly very interested in, and I'm sure you will find that as well. And we're joined very kindly by Caron Menashe from the Human Rights Commission, who's a Senior Community Relations Officer with the Commission there, who's come along today to talk to us about the Queensland Human Rights Act, which for some or maybe many of you, we're already aware that this passed into law in 2019, and it certainly outlines a number of responsibilities and obligations for many of us in the organisations we work for, in both public and also in non-government organisations. So before I say anything further, I'll hand over to Caron in a few moments' time, who will also further introduce herself and her role with the Commission. But just to let you know, in terms of the management of our webinar today, some people of you may be very familiar with the process. We will have the opportunity to hear Caron speak. And I think there's some nice interactive components today around some scenarios, which is always helpful in the way that we learn, as well as please feel free to pop into the chat any questions that arise, and we'll try and spend as much time at the end of today being able to go through as many of those as possible. Also today, there will be some handouts that are provided to you through links in the chat. So if you have any issues with those, we've got Niall online as our moderator to help out with any technical issues there. But without any further ado, I'll pop off and be in the background, but I'll hand you over and welcome Caron.
Thank you so much. Thanks, James. And thank you, James, for organising this, and to the team and preparing the scenarios that I'm going to talk to you about today. So as James said, I'm one of the Senior Community Relations Officers at the Queensland Human Rights Commission. Thanks everyone for joining me this morning. And I'm looking forward to just talking to you about the Human Rights Act and how it might relate to your work in particular. I've been with the Commission for 14 plus years, and only in the last few years doing training on the Human Rights Act, because as James said, it's fairly new. So I'd also like to acknowledge the traditional owners of the land on which we meet, where I'm sitting as Brisbane as the Jagera and Turrbal peoples. I'd like to pay my respects to elders past, present and emerging, and also note that the new Human Rights Act, or I should probably stop calling it the new Human Rights Act because we're almost into a review next year of it. It's almost 4 years old. So it will be, it acknowledges in the preamble to the Act the particular importance of human rights for our First Nations peoples. And that is recognised for the first time in human rights law in Australia in a separate section, cultural rights for Aboriginal peoples and Torres Strait Islander peoples. And that's been recognised in other legislation, which I'll talk about as well, but not as a separate section. All right, so just briefly today, I'm going to talk about the functions of the Queensland Human Rights Commission. I'm going to talk about the background to human rights law in Australia and around the world, modern human rights law internationally, and what it looks like in Queensland now. And very importantly, I'm going to talk about the responsibilities of us, you, me, and the organisations we work for as public entities to act compatibly with human rights, and how we do that, basically. And I'll talk about our human rights complaints process and a little bit about reporting requirements under the Human Rights Act. So the Human Rights Commission, the Queensland Human Rights Commission, folks, please note there is an Australian Human Rights Commission and there's the Queensland Human Rights Commission now as well. We used to be called the Anti-Discrimination Commission of Queensland. We are the one and the same organisation, but with the introduction of the new Human Rights Act, that changed our name to the Queensland Human Rights Commission in July 2019. So from the 1st of January 2020, we were able to start taking complaints also under the Human Rights Act of Queensland and anything that happened on or after the 1st of January 2020. We are able to review, we have a legal team. It's not a big legal team, but it's certainly bigger than it was in past years. We are able to help public entities review their policies, programs, practices, etc. But we're a very small team, so we only do that where it's strategically most needed. The job of my team, the community relations team, is to help people understand why we need human rights law, why we need discrimination law, how it can help them, and what their rights and responsibilities are under those pieces of legislation. And we will be assisting the Attorney General in 2 reviews of the Act. As I said, the first one will be coming up next year in 2024. And then after 8 years, there'll be another one because it's a brand new piece of legislation. And we can and we are, and we do have done a fair bit of intervening in court and tribunal proceedings, excuse me, where we feel that the court could benefit from our expert knowledge, or the parties could benefit from our expert knowledge on human rights law and how it might relate to the matter at hand. And of course, we continue to perform our functions under the Anti-Discrimination Act. So 75% of our complaints in the last 2 financial years were still coming in under the Anti-Discrimination Act, and there is a bit of overlap between the 2. So it's very important not to forget your obligations under the Anti-Discrimination Act as well. So the background to human rights law across the world is the Universal Declaration of Human Rights. That is the basis for a fundamental human rights declared after the Second World War, after the atrocities of the Second World War. They formed the UN. Australia was instrumental in forming the UN. Dr. Herbert Everett from Australia headed our delegation. They formed the UN Charter, and that set up the UN. And then Eleanor Roosevelt headed up a committee to develop the Universal Declaration of Human Rights. Australia was one of the nations that sat on that committee. And under that declaration, we have 2 covenants: International Covenant of Civil and Political Rights and International Covenant of Economic, Social and Cultural Rights. Australia is signatory to those 2 covenants, and all of our rights in our Human Rights Act in Queensland are drawn from those 2 covenants. And then under those, there are treaties, 5 treaties that Australia is signatory to around race, women, torture, children, disability, discrimination, and the Declaration of Indigenous Peoples, which we have recognised is a declaration. It's not a treaty. It doesn't require that Australia is a signatory to it, but that sets the basis for all of our how we view human rights in terms of our First Nations peoples. And because Happy International Women's Day, so I would like to mention a very important woman in this process, Jessie Street, who was the only woman on the delegation, the Australian delegation to the UN after the Second World War, to set up the UN and develop the Charter. And she was very instrumental in making sure that they're representing a group of women in Australia that were, campaigning for gender equity. And she was important in setting up, persuading the UN and all the members to set up a permanent commission for the status of women at the UN, and also to insert sex wherever it talked about distinction, which meant discrimination, and it was race and religion, and it also then she made sure they inserted the word sex, so sex discrimination was also recognised in those documents. So in Australia to date, we have 3 pieces of human rights legislation, only 3 folks. We do not have human rights law at the federal level. It's very important that people know that, because we'd like to see that. At the ACT was the first to bring in a Human Rights Act in 2004, and then we had the Charter of Human Rights in Victoria, 2006, and then Human Rights Act in Queensland in 2019, which our Human Rights Act is modelled heavily on the Victorian Charter of Human Rights, but we'll point out some differences as well. And so, we would very much like to see a human rights legislation at the federal level, but of course the next best thing is that more and more states and territories get it, and then hopefully we will see human rights law at the federal level as well soon. So the Human Rights Act in Queensland, what is it? What are the objectives? To protect and promote human rights in Queensland. Obviously, that's very self-explanatory, but to help build a culture in the Queensland public sector that respects and promotes human rights. So I'd like to say a couple of things about that. First of all, the Act doesn't say there is no culture that respects human rights in the Queensland public sector. Of course there is, but we can do a lot better. It recognises that we've got a lot, we've got room for improvement. And this, I'd like you to see the Human Rights Act as a tool to help all of us do better in terms of our actions, our decisions, the services we provide to the public, making sure that they're compatible with human rights. So, and I will give you a tool. There is a tool in one of the handouts with the scenarios. That's a very useful tool to actually make this make it practical. And when we talk about the Queensland public sector, we're not just talking about Queensland government or government. There's broader organisations, as you will know, many of you will be part of those organisations who are included in that Queensland public sector, and I'll talk about who that is and who those responsibilities fall on. And it's a model, it's a model of law that promotes a dialogue about human rights. It's not a litigious model of law, it's a dialogue model of law. It is not aiming to get people into courts and fight things out. It is aiming to get people talking to you and me, the public entities, to try and resolve a problem that they feel they have. And that's built into the human rights complaints process, and I'll explain that. And it's an act that recognizes the inherent dignity and worth of all human beings. That is really the basis of this piece of legislation of human rights law across the world. And when we talk about all human beings, we mean all people in Queensland, no matter what their visa status, have rights under both our pieces of legislation. And corporations do not, organizations do not have human rights. So I picked out some of the rights that I think are probably most relevant to you in the healthcare sector. Pointing out again that only individuals have rights, not organizations, corporations, or businesses. We have 21 sections of civil and political rights from sections 15 to section 35 of the Act, and they come from that covenant. And we've got 2 sections of economic, social, and cultural rights, section 36 and 37, and they come from that covenant. And it's worth noting that we are the first jurisdiction in Australia to protect the right to health services. So Victoria doesn't have either section 36, which is the right to education, or section 37, which is the right to health services. The ACT only has the right to education. So we're a little bit of the Rolls-Royce model so far in terms of human rights law, we feel, and hopefully there'll be a state or a territory that come along soon and do even better. But these are the rights that I've picked out. I picked out 16 of the sections that I think are most relevant to you in the health, working in the health sector. And, you know, you might recognize that there are others, but certainly these are really important for you to get to know. So there are 23 sections of rights altogether. I don't think you need to necessarily know the detail in all of them, but I would try and get to know the detail of the ones that you feel are most relevant to the type of work that you do. And that'll be about, you know, you looking at the work you do, you're looking at the situations where you might need to limit people's human rights. I'm going through the process that I'm going to show you with your colleagues, with some of the situations that you're dealing with, and actually identifying which rights are engaged, which rights might be limited, and learning much more about those rights. You have a handout today also, which has the full list of rights. If I can bring that up, it looks like this. So this is the full list of rights that are protected under the Queensland Human Rights Act, word for word as they appear in the Act. All right, so there are some groups that are more vulnerable to human rights than others, and I've sort of mentioned them here. Aboriginal and Torres Strait Islander people, of course, we know are more vulnerable in terms of, particularly in terms of the gaps in health outcomes. We know that asylum seekers, migrants, refugees, people from culturally and linguistically diverse backgrounds whose first language is not English, may not be able to articulate themselves, and people living in low socioeconomic circumstances, and people who are homeless would fall into that as well. people with a disability, including mental, intellectual, physical disabilities, all of those types of disabilities. We know that they make up the large majority of our discrimination complaints every year. And children, particularly those in out-of-home care, foster care, Aboriginal and Torres Strait Islander kids and seniors, all of those groups of people will be more vulnerable to limitations of their human rights and exploitation potentially, and discrimination, etc. So please be very vigilant when dealing with these groups of people and examine, whether you're acting compatibly with human rights carefully. Obviously, we need to do that with all the people we're dealing with, but when you're dealing with this group of people, an extra layer of vigilance, I guess, is needed. So who has obligations under the Human Rights Act? All three arms of government do, but Parliament, with every new piece of legislation will have to come a statement of compatibility with human rights now. That will state where the new bill, the proposed new law might not be compatible with human rights, so that anyone who needs to comment, make a submission or vote on the law knows upfront where that issue is. Parliaments can still vote this into law, even if it is not entirely compatible with human rights, but it does tell people right up front where that might be, and allow them to comment or suggest amendments. Courts and tribunals will have to interpret laws in a way that is as compatible with human rights as possible whenever they're making decisions about people in a hearing in a court or a tribunal. And public entities must give proper consideration to human rights and act and make decisions in a way that's compatible with human rights. Now, that's us and the organizations we work with, and this is the focus of today, what this means in terms of obligations of public entities. Who are they, and how can we understand our obligations better? So just quickly, I will say that public entities we are talking about, when we're talking about public entities, we have two main groups, which is core public entities. So those are Queensland government departments and any employees and ministers, Queensland government ministers, local government organisations and all employees and councillors, Queensland Emergency Services, Queensland Police, etc. Those are core public entities, which means at all times we have obligations under the Act. But we also have functional public entities, and I think some of you may be working for functional public entities. Those are organizations that are delivering functions of a public nature, performing functions of a public nature, delivering services to the public that are what we call of a public nature. And when they are doing those services, when you are doing or delivering those services, you also are public entities and have obligations under the Act. So these are the two obligations of public entities under Section 58 of the Human Rights Act, to give proper consideration to human rights when making decisions, and to act and make decisions in a way that is compatible with human rights. And I'm going to unpack those. So what do we mean by proper consideration? We first have to identify the rights that might be affected by an act or a decision. Now, they might be protected or they might be limited, either way, but we have to identify that. If we are identifying that we are limiting human rights in the decision that we make, we have to then consider whether the decision is compatible with those human rights, and I'll talk about that. We have to think how serious the impact is on the individual or the people that that are going to be impacted by a decision. And we also have to think about balancing competing private and public interests and obligations. So if I give you an example, during the first sort of year of COVID, our freedom of movement was restricted, sometimes very severely. Sometimes we couldn't go out with more than one person, or we couldn't go out to certain places. We could only go out for a walk or to do a bit of shopping, and so that our freedom of movement, Section 19 of the Act, was limited severely, and not as severely maybe in other states, but it was. And what happened there was the government looked at the public interest, the public health interest, and said, okay, the risk is too great. The public health interest here says we need to limit people's individual rights to freedom of movement, because the public health interest outweighs our individual rights to freedom of movement. So you can see how that might be a balancing act. You can also see balancing act in terms of one person's rights against another person's rights. So, for example, if a teacher decides to remove a very disruptive child from a classroom, and perhaps that child is behaving that way because of whatever reason it is, but that person's right to, that child's right to education is being limited the moment they're removed from the classroom. But possibly at that moment, all the other children's right to education is also being disrupted because of the child. So weighing up, a whole classroom of children's rights against one child's rights. And of course, then they have to think about how they deal with that situation further on and make sure it's not a permanent situation and that child gets back into the classroom as soon as possible. But weighing up those one person's rights against another group of people's rights there. So human rights is always an issue of balancing. So proper consideration, what does that require? There was a landmark case for us in Queensland into 2021, which was about Mr. Owen Darcy, who was who's a convicted murderer. He's a very violent murder. He was convicted, I think, in 2011. In 2013, he was further convicted of assaults on prison officers and an attempted murder of a prison officer in prison, and he received further convictions. And at that time, the executive of Queensland Corrective Services put a maximum security order on him and said, right, that means he's in isolation for 6 months. Since then, it was rolled over every 6 months, and he pretty much had been in isolation for almost, I think, 6 years by the time he challenged this in court. And he challenged it, he was able to challenge it in court via another process, but also piggyback his human rights concerns on their humane treatment when deprived of liberty, for example. And he probably raised protection from torture, cruel, inhuman, degrading treatment, section 17 of the law. And the court wanted to know whether the decision maker had given proper consideration to Mr. Owen Darcy's human rights, and found no evidence that the decision maker had seriously turned their mind to the possible impact of the decision on Mr. Owen Darcy's human rights at all, and therefore sent the chief executive of QCS back to the drawing board and said, okay, you have to really think about this carefully. You haven't given proper consideration to Mr. Owen Darcy's human rights. You've got no evidence of that. You will have to think of a way to keep everyone safe around him, and the people who work there safe, but enable him slightly less restrictive measures to enable him to have some kind of human contact, because the impact on his human rights is significant right now, and his health, his mental health. And really important, if you are thinking about something and you might be limiting human rights and you think it's reasonable and justifiable, please document it, folks. Don't need to write War and Peace. So you can use the process that I'm going to give you in a little while to document that, answer the questions, and keep that as a document of why you think you need to do what you're going to do. And the important thing that this case and many other cases have noted is that it's not a sophisticated legal exercise. You do not need to be a lawyer to identify which rights are going to be limited by your decisions or your actions. So acting compatibly with human rights, Section 8 talks about that we are acting compatibly with human rights if we do not limit a human right. Obviously, we're acting compatibly with human rights, but if we are limiting a human right, we can do so, but only to the extent that is reasonable and demonstrably justifiable in accordance with Section 13 of the Act. So as I said, demonstrably, that's an important word. It means that you've actually recorded your thoughts and your reasoning behind why you think it's reasonable and justifiable to limit this person or these people's human rights in this way. So to decide if a limitation is reasonable and demonstrably justifiable, the public entity, we must consider the nature of the human rights limited, how severe is the impact, the importance of the purpose of the limitation. So we have to identify our purpose, why are we doing this, and how important is that? And then we have to look at the relationship between our purpose and the limitation and the proportionality of it. So, or how important, the importance of our purpose, how does that weigh up against the effect, the impact on the person of limiting their rights? And the really important question we have to ask ourselves, is there a less restrictive way to achieve our purpose? We always have to go to the least restrictive measure reasonably available to us to achieve our purpose in order to be acting compatibly with human rights. And I'll be illustrating this and how that works. So I'll give you an example of a case that was heard in Victoria, which was deemed to be incompatible with human rights, not compatible with human rights. So this was a young woman in a train station in Victoria, suspected of not having a valid train ticket. 3 security officers who are tasked with the work of making sure everybody has a valid train ticket approached her to detain her until the police arrived. Now, the way they did it was they spear tackled her to the ground and held her face down on the ground for about 8 minutes until the police arrived. 3 officers basically sitting on her. And so when we look at what they had to consider, well, the nature of the human rights that she raised in the hearing was protection from torture, cruel, inhuman, and degrading treatment. As you can imagine, it was extremely embarrassing and humiliating to be treated like a dangerous criminal in front of hundreds of people in a busy train station. Probably she also could have raised humane treatment when deprived of liberty. So she was deprived of that liberty at that time, but not being treated humanely, she didn't feel. And the importance of the purpose of the limitation. So why did they limit her human rights? Their purpose is to make sure that everyone upholds the law, which says we all have to pay for our public transport. And so they did have an important purpose to achieve there. That's their job. But then we looked at the relationship between the purpose and the limitation and the proportionality. And CCTV footage and witness footage, because people filmed it on their phones, they were quite shocked when they saw it, showed that she had no weapons. She was not posing any danger to the officers. They could easily have achieved their purpose in a less restrictive manner. And so it was deemed not to, their reaction, the way they went about achieving their purpose was not proportionate to the risk involved. And in terms of outweigh and did not outweigh her right to be treated humanely. And so was there a less restrictive way for them to achieve the purpose? Certainly there was. You know, the footage clearly showed they could have just stood around her, the 3 officers. They would have been able quite easily to have stood around her and just, prevented her from running away until the police arrived. They didn't have to do it in the way that they did it. And so their actions were deemed to be incompatible with human rights. So the practical steps for assessing compatibility, we worked with the Department of Justice and Attorney General Human Rights Unit before the Act came into force to try and translate, that those sections of the Act into something a little bit more practical, and questions that you can ask yourselves in order to be able to check whether you're acting compatibly with human rights and document it. And so we came together. We came up with this process that I'm going to show you now. And so we ask ourselves whether the policy or the decision or our action does limit to human right. If it doesn't, then you'll see this no here, the policy or decision is likely to be compatible with human rights. But if we recognize that it may limit a person's human rights or people's human rights, and there might be multiple rights limited, by limiting that right, are we achieving a legitimate purpose? Do we actually have a legitimate purpose? And it's not always the case. So we really have to think very carefully. I'll give you an example. In Victoria, there was a gentleman who was in a hospital. The hospital, the doctors and nurses all agreed that they didn't think he should be going home. He should be going to a care environment where he would be looked after. They didn't think he would be safe going back to his home on his own. And he was very attached to his home and he wanted to go back home. And they thought, so a good idea would be to ask the public guardian to apply for permission at VCAT, which is like our QCAT, to sell his property, sell his house. They thought that, if we sell his house, if his house is sold, he won't be able to go home. He'll have to go to a supported care environment. And of course, he said that, his property rights were being severely limited. That's our section 19 of our act. And unreasonably, unlawfully, and arbitrarily, he was being deprived of his property if that would happen. And in the hearing, they determined, well, in actual fact, your purpose is to make sure he's safe and trying, go into an environment where he will be helped and looked after. but that does not justify selling his house from under him without his consent. And so, yes, the purpose was achieving a legitimate objective, but did the objective actually achieve the purpose? It did the limitation achieve the purpose? Probably not in that similar situation. So is the limitation reasonable and justifiable? If it is, then the action is compatible with human rights, even if human rights are being limited. If it is not, if you cannot show that it's reasonable and justifiable, then the policy or the decision is unlikely to be compatible with human rights, and you will need to amend your activities or your decisions. So let's have a look at your scenarios. We're going to in a moment. And this translates into these questions, which you have in your handout with the scenarios. And I'll just show this to you in a moment as well. So first thing to ask, which rights are relevant? Am I limiting a person's human rights here? Maybe I'm protecting a person's human rights. So Department of Child Safety, or Children and Youth Justice, they're now called, would say that if they're removing a child from a family, they're doing so in order to protect that child's possibly right to life, what's in the child's best interest. So right to life, section 16, what's in the child's best interest, section 26, protection of families and children. So subsection 2, protecting what's in the children's best interest. They would say they're protecting those rights. The family might say, well, actually, we think you're limiting our rights to privacy and reputation. That's the right not to have the family arbitrarily interfered with. The right to protection of families, section 26, which is protecting the family unit, which is the fundamental unit group of society and deserve protection. So you can see how there might be rights limited and protected at the same time in different perspectives. From different perspectives. What's the impact? So if you identify that in actual fact there are rights that are limited, you have to go to step 3 and ask yourself if the limitation is reasonable and justifiable. And this is broken down into 5 sub-questions to ask yourself. Is it lawful? Do I have legal authority to do this? Is there something in some piece of legislation that says I can do what I'm doing? If it doesn't, if there isn't, and we're not talking policies, folks, we're talking legislation. If there isn't something in some legislation that says you can do this, then perhaps you're acting incompatibly with human rights. Do I have a purpose? Do I have a legitimate purpose? I have to clearly identify my purpose and make sure it is a legitimate purpose. Then is it rational? Are my actions actually going to effectively achieve the purpose? As with that situation with that gentleman in Victoria, where they decided they would ask the public guardian to try and sell his home, the hearing on his human rights determined, well, actually that wasn't rational. We don't think that limiting his property rights would have achieved the purpose of him being in an environment where somebody would care for him. And is it necessary, or is there a less restrictive way reasonably available to me to achieve my purpose? And finally, when I'm weighing it all up, do the benefits of me achieving my purpose outweigh the harm of me limiting that person's human rights? So let's look at this in context of your scenarios. So I've been given scenarios by James and the team, a couple of them. So you've got them in more detail in your handouts. Let's just bring that up very quickly. So you've got the slightly more detail on the and sorry, I've mixed up the order of the scenarios. So then I'll be doing number 2 first and then number 1 second. That's a little bit more detail than I have on the slide, and the questions are there. And I really, really encourage you to learn to use this process. Every time you've got a situation and you're thinking about, am I limiting a person's human rights, use this process to determine whether you're acting compatibly with human rights. So back to the scenario on your screen. So Sue, she's attending drug and alcohol counselling to support a recovery from a methamphetamine use disorder. It's part of court-based conditions. At her last appointment, her counsellor notices that she's wearing some new clothes and jewellery that look quite expensive, and she wonders how she could afford that. And she then sort of thinks, I wonder if she's involved in criminal activity again. You're wondering how she can afford those expensive new clothes and jewelry. She confirms Sue's attendance with the agency that's supervising the attendance at counselling at the agency that's supervising Sue's court order. But also at the time voices her concerns that Sue might be engaging in some kind of criminal activity to afford these new clothes and jewelry. She doesn't really think much of it, but then what happens afterwards is that the worker from the agency supervising Sue's court order decides that Sue needs a higher level of supervision and tells Sue this. And that's pretty much the end of the matter. Sue tries to explain that it's actually her parents had given her these clothes and jewelry as gift because they thought she was making really good progress in her recovery, but the worker doesn't want to hear it and just remains steadfast in their decision to increase her level of supervision. So which rights are relevant here? Now, I'd say that I'm going to ask you quickly to try and share on chat. Let's see if we can do this. I know there's a lot of people in the Zoom room today, but let's see if we can do this. I'm going to, again, share what you need to look at. So the handout of the rights. So which rights are relevant, what rights are protected in Queensland Human Rights Act. Just have a quick look through that. You'll have it. There is a handout and there's a link there in your chat. Have a look through that and see if you can identify which rights you think might be limited for Sue in this situation. And if you identify that rights might also be protected, possibly you might want to put that in, but I'd like to focus at the moment in which rights might be limited for Sue. So if you can just spend a minute trying to identify 1 or 2 or 3 rights that you think might be relevant in this scenario. And I'll bring back the scenario so you can see it. And I'll keep my eye on the chat. If you can put something up on chat, folks, that would be great. Now you can put numbers if you don't want to write the whole name of the section. You can just put a section number in there. But which rights do you think, which of Sue's rights might be relevant here? And I'll bring up step 2. Are the rights limited? So I would like to focus on which rights might be limited in this situation. Number 25, so we're looking at privacy and reputation. Yeah, so first of all, it's her counsellor in disclosing this information perhaps has limited Sue's right to privacy in this situation. Section 15, recognition and equality before the law. Yeah, so perhaps she's being judged, discriminated against, not in being able to enjoy her rights without discrimination. Decision was based on assumptions, not on facts. Yeah, so that's for sure. So, and I'm also thinking if we look at, go back to the list of rights. So recognition and equality before the law, section 15. You've mentioned privacy and reputation, not to have the person's privacy unlawfully or arbitrarily interfered with, and also subsection B of that, not to have the person's reputation unlawfully affected, unlawfully attacked. So really that's what's happening here as well. And Debbie, you've mentioned section 32. Now, I'm not sure if Sue was under 18, we'd probably be looking also at protection of families and children, subsection 2. I'm not sure if you would deal with minors, but every child has the right without discrimination to protection that's needed by the child and in the child's best interest. And 32, so rights in the criminal proceedings. So there would be something in there that probably would be relevant because she has been there's a court order, so she's probably got a conviction against her. And so I also think that possibly we're looking at agree, opinion, not fact. Yeah, so, and possibly we're also looking at 31, a right to a fair hearing. So I'm not sure of the process that then would the person would go through, if there would be some kind of civil process that would determine that increased supervision. Possibly we're looking at the right to fair hearing for Sue. Okay, so we've identified that some rights have been limited. 31, sorry. Yes, okay. And there's probably something, depending on Sue, what her conviction, what level, if she's convicted, charged, where there might be something in sections 29, which deals with the criminal justice process, and 32 as well. If she's underage, 33 children in the criminal process as well. So let's go back to the scenario. Is the limitation reasonable and justifiable? So we've seen that we're fairly sure that some of Sue's rights have been limited, as you've mentioned. We have to ask ourselves, is it lawful? So is there a legal authority and framework to do so? So I don't know the answer. Where can I access the handout? So Kaz, there are links.
Sorry, Caron, James here. So we have popped them in the chat, but we will resend them.
Yes, because maybe somebody's joined after.
But we'll resend them.
Thank you. Excellent. There you go. There they are. Okay. Okay. So we have to answer this question: is it lawful? Is there a legal authority or framework that allows the worker to increase Sue's level of supervision in this way? Now, this is not my work. This is your work. You're the experts in your area. You will know what part of what piece of legislation, hopefully you will know, allows the worker to do this, to increase Sue's level of supervision. So if you don't, please make it your business to do so if you're involved in this type of work. So whenever you're making the decision, please make sure, and if anybody does know what section of what piece of legislation allows the worker to increase Sue's level of supervision, please put it in the chat there. But you do need to know this. So make sure that when you are limiting a person's human rights, make sure you know which piece of legislation and which section under that piece of legislation allows you to do that. Now, if you have any discretion at all under the legislation in how you do that, that's when human rights kick in. So that's when your obligations under section 28 kick in. If you have absolutely no discretion, if you have to do it only in one way, and that's the only way you can do it, then section 58 of the Act, your responsibilities will not apply. But if you have any discretion whatsoever, you have to then think about what's your purpose. So in this situation, I'm thinking the purpose is, I'm not sure, what is the purpose of increasing Sue's level of supervision? That she doesn't, to monitor her activities, that she doesn't commit another criminal offense potentially. I'm not sure. If anybody has any ideas, please throw it up on chat there. You know, what purpose would the worker do and have for increasing Sue's level of supervision? That I'm guessing as somebody that's not my area of work, to maybe monitor and make sure that she's not committing further criminal offences. Is it rational? Will it effectively achieve the purpose? Well, possibly it might achieve the purpose. I don't know how they would do that in terms of what could they monitor all the time? How would they monitor? What would that mean, the increased level of supervision? Really depending on what that would mean. And then the question that the worker needs to ask here, is it necessary? Is it the least restrictive way? Now, I'm going to go back to some of the comments that you made earlier. Jack says, I guess the decision was made on assumptions and not fact. And James agrees, opinion, not fact. So I would say then that because the worker has really just taken the counsellor's opinion at face value and just made a decision to increase Sue's level of supervision without really investigating further, I'd say that possibly it's not the least restrictive measure reasonably available to her. She needs to do further investigation. Depending on how she monitors, increases her level of supervision, if there are different ways in increasing the level of supervision, does she go to the most extreme measure? I don't know, could she put a bracelet on her, something like that? It's pretty extreme. Does she need to do that yet? Has she really got all the facts at her fingertips to actually reach this decision and take this action? And I would say probably not based. And also you've also said probably she doesn't have really enough information to go that far. And therefore probably the benefits are not outweighing the harm of limiting Sue's human rights. Okay, so the next scenario is about Jerome, an Aboriginal man in Queensland who is prescribed methadone to help with an opioid use disorder. He lives in Queensland, but he originally comes from New South Wales. He's found out that a family member in New South Wales has passed away, and he wants to travel to the funeral with some family members in Queensland. He contacts his methadone prescribing service, and he says that he's planning to travel. He'll be away. He's going away in 4 days. It's just happened. He had no notice, obviously. They weren't expecting this. And he'll be away for 2 weeks as part of sorry business. So, and he says that he's found a pharmacy in a nearby town that has agreed to dispense the methadone for him. And that he asks for the service to provide him with a script. But the service refuses this request because he's asked for this many times before. And anyway, they say they have a policy. They need a minimum of 7 days notice for an interstate script. And so Jerome ends up not being able to attend the funeral, which is very distressing for him and for his community as well. So which rights are relevant here, folks, do you think? If you have a look at your handout again, which rights are relevant? Do you think for Jerome, particularly, let's focus which rights have been limited? Sections 28, cultural rights for Aboriginal people and Torres Strait Islander people, and sections 37, thanks Debbie, that's right to healthcare, health services, 28 and 27. So probably 27, you would only look at if you weren't sure whether a person was Aboriginal or Torres Strait Islander, because you know that he is, Samantha, probably only 28 would be relevant in this situation. But sometimes if you're not sure what a person's culture is and you think that there are cultural issues at stake, you'd look at 27. 19, freedom of movement. So yeah, his freedom of movement is being restricted here, James, for sure. That's correct. So he's not being able to, and freedom of movement says that we're allowed to move in and around Queensland and out of the state as well, and also to choose where to live. So he's not being able to move out of the state because he's not able to access Section 37, right to health services. So we can see that Jerome's rights have been limited here by the methadone prescribing service making this decision and refusing to accommodate his request. Is the limitation reasonable and justifiable? So is it lawful? Do they have a legal authority to say, sorry, we can't dispense? So this is a policy. They're saying this is a policy, but it's not law. Or is it law? I don't know. They're saying they have a policy. This, but is it in law that Jerome has to give 7 days minimum notice? If not, if there's nothing in the law that says that Jerome has to give 7 days minimum notice to get a script, if he has to go away for an emergency, then right up front, there's no, and right now, all I know is that they say they have a policy. But if it states somewhere in law, well, that's then it's probably acting compatibly with human rights. But if not, if it's just a policy, probably not. What is their purpose? I'm not quite sure what their purpose here is. I guess, making sure that methadone prescriptions are not abused, misused. I'm thinking, I don't know. This is not my area of work, but I'm just sort of guessing maybe that's their purpose in being quite strict about issuing scripts for methadone. Is it rational? Will it effectively achieve the purpose? Well, yes, it will achieve the purpose of making sure that scripts are not misused or overissued or that kind of thing, if I'm correct in guessing that. But is it necessary? Is it the least restrictive way? Now, if they have any discretion in that policy at all, and if it's even if it is stated in law, if they don't have any discretion, if they can only give scripts with 7 days notice, well, that's fine. They're acting compatibly with human rights. But if they have any discretion at all in this situation, where really Jerome, he's not to know, a family member dies, the funeral's coming up, he won't be able to give 7 days notice of this, and his cultural rights are very important. All of our rights to attend our family members' funerals are very important, not only if we are Aboriginal and Torres Strait Islander people, but of course, sorry business is very important for them. So, I would say that it's not necessary. there is less restrictive measures reasonably available. Jerome has made sure that he can find a pharmacy who will be able to prescribe to issue the methadone. And I can't see really, unless it's written into law that the script can only be issued with 7 days notice, that it would be that they could not accommodate his request and that it would be fair and balanced. And so, you know, outweighing the harm of denying him his cultural rights and his right to attend his family funeral. So family, I'd say privacy and reputation, section 25 is also relevant here possibly, because, you know, it's interfering with his family. He needs to attend his family member's funeral. That's very important for us. So I would say probably not acting compatibly with human rights unless there is some legal section of some piece of legislation that says a methadone prescribing service can only prescribe a script and can only issue a script with 7 days notice. And so they really would have to, I think it would find it hard for them to say that it was reasonable and justifiable. All right, folks, so please use this process with any decisions that you're making that will impact on people's human rights. And it will help you really work out whether you're acting compatibly with human rights or not. So under the Human Rights Act complaint process, the complaint first goes to you, the public entity. You have 45 business days to resolve it. Please note, though, that if it is a complaint that might also be accepted under the Anti-Discrimination Act, and if the complainant decides to do that, we will let them know that they could, then we will accept the complaint directly and you won't have that 45 business days to deal with it. So please take notice when you think something might also be something that's covered under the Anti-Discrimination Act. We might sometimes accept a complaint earlier than 45 business days if it's an urgent and exceptional circumstances. If we do have a complaint, we'll be asking the person who's complaining, how has the public entity responded? If they say, I haven't been to the public entity, we will refer the complaint back to the public entity, to deal with and to respond. If the public entity does not respond within 45 business days or provides an inadequate response, we will accept a complaint and attempt to conciliate it at the commission. And you know, an adequate response could be you explaining to the complainant why you had to do what you had to do and that you had no other way of doing it. Or it could be you discovering, your agency discovering, well, actually, we could have, we had less restrictive measures reasonably available to us, and we're going to change our decision slightly. Or maybe we shouldn't have made that decision at all. But hopefully, you will enter into a genuine dialogue with the complainant for 45 business days and try and come up with some sort of solution. When you look at the complaints that were accepted in 2021-22, freedom of movement was a very large one. Obviously, we had issues with COVID. Recognition and equality before the law, it's always massive. Privacy and reputation, always massive. And humane treatment when deprived of liberty, torture, cruel, inhuman, degrading treatment. And then you'll see that taking part in public life, fair hearing, right to health services, freedom of thought, conscience, religion, belief, freedom of expression, protection of family and children, right to liberty and security of person also feature very heavily, and even right to life featured quite heavily. So you can see this in our annual report. We will refer complaints to the Ombudsman or the Queensland Health Ombudsman if we feel that they can deal with it more appropriately than we can, with the complainant's consent. And we may refuse to accept the complaint if the complainant doesn't consent to that. And there are reporting requirements for Queensland government departments. And we will be asking also organisations for information about human rights and complaints and how they've dealt with things. And also we will be recording anything that happens with a public entity in our human rights legislation. All right, so do we have any questions? So I've been keeping my eye on the chat.
Hi, Caron.
That was quick and dirty.
Well, I think you know, lovely kind of summary of what is a lot of information, and I like the way that you put that at the beginning around it's really not trying to be litigious. It's about how organisations can try and do better. We do, particularly from a health service perspective, wish to become from that kind of person-centered and
yes, we do.
Absolutely, and getting people together to talk. So I guess a question that I have, and I'm just looking at what else is on the
So Kim's asking if we're going to get sent a copy of the PowerPoint. So I think you're going to turn it into a PDF and send it to everyone.
Yes, it'll be available as a link
as a PDF
on our website on the past recorded webinars site.
Thank you very much. Thanks, Kim, for the question.
So just in terms of so a complaint, whether it be Sue or Jerome there that we spoke about, or any of others, it goes to an organisation. An organisation is therefore required under the Act to enter into conversations and to deal with that in good faith. That could be that they provide a rationale that
could be
that there's a legitimate reason, or it could be that they make an apology, or that they indicate how they're going to change practice or something in terms of this going.
That's usually what people want, is some change to the decision in some way. But you might not be able to do that. I mean, it might be that you've got to do what you've got to do. So, but really it goes a long way to explaining often to people why it is that you have to do what you have to do.
And a person who made the complaint can either be satisfied with that. If they're unsatisfied, they then can make a complaint to the Human Rights Commission. What would be what's the range of responses that can come from the Human Rights Commission? I know you mentioned there that it could be referred to the Health Ombudsman if it's more related to, sort of things coming under that kind of area. But what are the other types of ranges of responses?
Well, if the commissioner feels that there's the Queensland Ombudsman or the Health Ombudsman or can deal with it, or there's a couple of other organisations can deal with the complaint more effectively than us, their process is more suited to their process, we will refer it. We will ask the complainant. We say to the complainant, look, we think this organisation can deal with it better. And with their consent, we'll refer it to them, and then it's out of our hands. But if not, then what we're looking at is we're just looking at, okay, so have their human rights been limited? If they have, then we'll probably have the 45 business days passed. And then we'll be asking the public entity about how they've responded. The public entity will give us information about how they've responded. Sometimes we've had in the past public entities said, yes, we told them it was reasonable and justifiable with no detail at all. And in that case, in that case, we're just going to accept the complaint and arrange a conciliation conference with our conciliators, because that's not enough information. But if the public entity comes to us with a lot of information and explains, why they've done what they've done, why it was reasonable and justifiable, we might not accept the complaint. We might not continue and run with the conciliation. If we're not satisfied, if we still think, that's not really an adequate response from the public entity, we'll hold a conciliation. And that's usually confidential. It's informal. It's at our offices or on teleconference sometimes. And then we'll try and help the parties reach some sort of an agreement. If they can't, that is the end of the matter with human rights law. However, if we identify that the complaint could also be taken under the Anti-Discrimination Act, we will be telling the complainant that. And we will be not recommending, but we'll certainly be telling them what the advantages are of them taking a complaint under the Anti-Discrimination Act instead of under the Human Rights Act. And those are two advantages. One, they don't have to go to the public entity at all. They can come straight to us. And two, very importantly, if they have no outcome at the conciliation, they can ask for the complaint to be referred to the Queensland Civil and Administrative Tribunal, or to the Queensland Industrial Relations Commission if it's a work-related complaint. And that's a very important difference. So certainly that could also happen as well. That's pretty much the range of what might happen to a complaint. We could also just refuse to accept it if we think it's frivolous.
No, and thank you. And thank you for that. And there's some lovely comments coming through. There was also a question here, but just before I get to that, I just want to acknowledge, while everyone's still here in the webinar, that in the scenarios, I know, having worked in this field for a long time, that people would work with compassion around those situations and everything like that. But they were scenarios to represent, I guess, a process and to give us examples of how to work through that. So, just want to acknowledge that there's a lot of very caring. And
sometimes people are just under the pump, and they're busy, they're stressed, they make assumptions. I've got to. and they're under the pump to make the right decisions, and that's tough, so we understand, and that's why I say there's no suggestion that there is no human rights in the Queensland public sector, but just that we need to have this. Just helps us think a little bit more carefully. There is a question though in there.
Yes,
Kim,
I see that. Yes.
Does the QHRCC case examples the crossover between human rights law and industrial law, noting this synchronicity with fairness and reasonability? How is the outcomes managed? So, depending on so you might be looking at, with discrimination law, we often see overlap with industrial law. We'll often see, people losing their jobs because they've been discriminated against because of a protected attribute, that kind of thing. That's usually where we'll see the crossover, or in terms of compensation, workers' compensation. We often see people coming, you might see people coming to us with a complaint because they've applied for workers' compensation. The organisation hasn't provided enough information. QComp has determined that the injury wasn't sustained at work, and then they come to us with a discrimination complaint. So you'll sometimes need it, and fairness and reasonability, or you'll see this across all these types of legislation in terms of, dealing with someone. The reasonable person test exists in the Discrimination Act and sexual harassment, exists in the workplace health and safety, in bullying and harassment. So those kind of concepts cross over a lot. I don't know if that's more generally, does QHRC have a website containing examples? Yes, our website is absolutely wonderful. We've got case scenarios, we've got so it's just fact sheets. We've got lots of great stuff on our website. If you can't find something, just give us a call on our 1300 number and we'll help you find it.
Oh, that's very generous. Thank you for that, Caron. Now, I was wondering if you want to flip to your next slide, because you've got your QR code for,
so folks,
evaluation.
I would appreciate, I know you've got another evaluation to do, but if you do have time to go to slido.com and put in the code C169, or just use the QR code there.
And we put the link directly in the chat. So you can also use the link to take you straight there to the survey in the chat for Caron. So a couple of options there. And yes, there is a survey as you leave our website as well. So hopefully you'll do at least one.
Yeah. Please share with us. It just helps us improve what we're doing all the time to get feedback from you all.
And Caron, I hope you've been seeing, people have loved the summary. I think it's been thought-provoking in terms of just some of the comments, and
thank you.
One or two people are making these comments, then that's shared amongst many, as well as the examples have just really kind of helped people to think through, okay, well, what are some of my obligations, responsibilities, whether I'm in public or whether I'm actually delivering services on behalf of the state, in this case, because that equally applies.
Yes. And thank you to you. You came up with the scenarios, not me.
Yeah, that's okay. Look, I guess we've gone to our time of 11, and there doesn't seem to be, just some lovely comments coming through that. And I know also on your website as well, there's a link to a free e-learning on covering some of this information, probably very similar, but and there's also a paid version, which is public entities in the Human Rights Act. It's a few dollars per head, which covers more in depth in terms of the responsibilities of public entities. So I encourage you to keep learning. Yeah, because this is very real stuff that sometimes we don't always have a good grasp of.
And if anyone wants a private session as well, we can do that. And we've also got public sessions like this on our website, virtual or face-to-face.
Oh, look, that's great. Look, Caron, without any further, questions that have come through, just really want to say on behalf of our team here at Insight and also our sector, this is it's been very much focused on the Queensland side of things, which is very important because that's where the majority of our audience comes from, and I'm sure for those that attended today. So we really appreciate your sharing of this great information, these great summaries and the resources, and also the other ongoing things that people can explore and investigate should they wish to go deeper. So thank you. And on behalf of everyone, we really appreciate you, and please also thank those in your team that have supported this today as well.